So how do you really get an acting judge to look at what you're saying? And that is what the judicial decisions are based on. In other words, as it applies to the judicial department, legislative fact has nothing to do with the legislative department. It is strictly res judicata's, stare decisis, and other things such as the rule of evidence and the rules of civil procedure in harmony with those. The aid of a counsel. The moment they read that and you start to cite case law, they cannot take judicial notice of that. Why? Because judicial notice has a scope, the rule regarding it, and the limits of what it's dealing with is strictly based on adjudicative facts only, and carries way more weight than all these other cases that people try to cite in their case laws. Do you see now why you should never cite any case laws in your piece of paper? The moment one cites a case law in their piece of paper, they have effectively killed the power of their situation. Because one, the acting judge is now not bound to look at it. Because the only way they can take judicial notice, judicial meaning to invoke the power to make a judicial decision according to the operation of law conferred to them by the Constitution, based on the 3 departments of government, judicial branch being one of them. How can that judicial branch's power based on the Constitution? Spoken of here initially. How can it ever be invoked if the limits of how they can look at paper is been abrogated by you, the one bringing the paper in, which is judge-made law, aka res judicata. And the way that they're able to look at any given preponderance of evidence before they determine its applicability, before they determine its admissibility, before they determine its authenticity, before they determine its exceptions as it applies to you. This comes first. Judicial notice. Notice is how someone takes notice of something. It speaks for itself. You want them to take notice of what you put it in? It's called a judicial notice. They have to take notice, right? It's right here, judicial notice. And they're letting you know the scope of what we will take notice of is strictly based on this. Is the reason why you should never state stare decisis. And if you state stare decisis, use the dynamics of how it's been used, not necessarily just making reference to it that, okay, there's this court order that says this man cannot do this, and because of that, you cannot do it. So here's this Wade versus Road, Miranda versus Arizona. Link it like a puzzle piece into yours and say, for instance, Miranda versus Arizona. You can have everything proper if you don't put it through judicial notice, and one does not comprehend what judicial notice constitutes in its scope. Nothing is going to happen. One would know that they have everything right and proper, yet somehow it's not working. Many people who are frustrated by the quote system, and they're saying the system is fixed, it's because they don't read what is written in black and white. It's right there in front of us. These are the intricacies that those who are successful with pen and paper gain, whether they come in as plaintiff or as defendant, or they're doing something in between it all. These are the small things they will not tell you, and if they tell you, they will casually speak of it in the middle of the conversation, and they will just throw the word out there, and then they will just keep on moving. To those who see the highlight within the conversation, they will look deeper into it, but most would not. And even when they begin to look in deep into it, they will misunderstand what they're reading right on its face. Why? Because the power of doublespeak, because the power of legalese. They structured these things so much so that once you do finally somehow get to look at it in black and white, a complete 24 minutes video is on the Patreon page. Take care. Best of luck.